affidavit, supporting affidavit. Will not rely on it. And paragraph 10 of the same affidavit will not rely on the same. But the standard, Your Lordship, is that of a bystander. Ahmed Nasir spoke, and he has a following of over 1 million on his Twitter handle. That is, the perception has been created to the Kenyans that this bench, 1, is a conveyor belt, 2, it is considered for a particular mission, 3, it's part of the conspiracy. Your Lordship, we urge you to uphold our application and grant the prayers sought. Your Lordship, my learned friend Mr. Masharia will highlight on the authority with the authority in support of my submissions and those of Kibe.
Sorry, just a slight clarification on the expiry. Paragraphs 10 and 16, if I had properly.
Yes, that's correct.
Of the supporting affidavit.
That's correct.
I don't know whether we can do that through oral submissions. You cannot expurge a paragraph from an affidavit as it is evidence before the court, and it has to be considered, it has to be challenged in all ways. Number 2, if you expurge paragraph 16...
Can you cover it in your response, please?
I may, but if you expurge 16, I have a problem with that. There is no application before you. If you expurge paragraph 16 from the affidavit, there is no application as being urged before you. So we need all this clarification. Let's not take things lightly.
Yes, Your Lordship, yes, it is true that the paragraph that I seek to expurge is paragraph 16.
Can, Paragraph 16 of which affidavit? By who?
It is the affidavit of the 22nd of November, paragraph 10, and 16 is the
applicant's affidavit.
impeachment.
That is Obuli Namenya.
This is 10, 16 is
My Lord, permit me with
perhaps, my Lord, again, because we have to be fair to the court, my colleague has to be candid and confirm to the court. The reason he is withdrawing that paragraph 16 is because the claim there is factually false. Because you can't just withdraw and leave the world thinking...
we are not even seeing that paragraph 16. Can you read it, the paragraphs we want to withdraw?
And 10 and 16.
Your Lordship, are you having the same...
Read as paragraph 10, which we want to withdraw, and paragraph 16, so that we can consider if it can be withdrawn.
in English, just read it.
We give Mr. Devoa, my lords, your leadership, the opportunity to finish his submission.
Yes. Let him read those paragraphs,
Yes.
so that we can sit down.
No, I agree. I'm just saying, protect him from these tutorials that he's getting from this side.
Order, please. Order. Please read as paragraph 10.
Your Lordship, I wish to say that most respectively, I wish to say no more in respect to the paragraph.
This is a direction from court. Read paragraph 10 and paragraph 16. Read
Paragraph 16 reads,
paragraph 10 first.
May I have some peace, Your Lordship?
No, listen, please, listen.
Your Lordship.
Listen.
Who is in conduct?
Listen. Bana Njiru,
Yes, Your Lordship. I'll read.
you have applied to expunge
Yes, Your
paragraphs 10 and paragraph 16.
Yes, Your Lordship.
Can you read those paragraphs which you intend to expunge?
Your Lordship, paragraph 16 says that...
Paragraph 10.
And Your Lordship, may I take note that these paragraphs have been expunged?
We have not expunged those paragraphs. It is your application.
Expunged them. The petitioners have credible information that Honorable Mrima is a close associate to the proposed deputy president, one Mr. Kidore Kindiki, and that the said judge failed, refused, or neglected to disclose those facts to the parties at the inception. The basis of the application to expunge that particular paragraph is on the basis that the same has been linked to the affidavit sworn in petition 015. Paragraph 16, that Lady Justice Mugambi is conflicted as she should recuse herself, as she was Mr. Kidora Kindiki's LLM student at Moi University.
We have no LLM program at Moi University.
Professor
You
Jenda,
have your time to submit, sir. Don't eat him. And that's why I'm expunging it. That's why I'm expunging this paragraph. That is what my client said. A crucial issue that she failed and or refused to disclose to the parties. My client has learned that she was not an LLM there and that she only took her degree in that university.
We have no objection to anything being expunged, subject to the court observing that if this witness has lied about these two issues, what else has he lied about?
In a ruling, because application has been made and the response is there, but we decline the invitation to expunge those paragraphs. They will remain as part of the record. Dr. Kamuna, we would appreciate if you want to address us in the course of the, as in you are submitting. Is that the position?
Yes, that's right.
Okay, proceed.
My position is that there is a party.
Are you supporting the motion?
I'm supporting my line of friends complaint to the neighbor and you as my friend is a kid.
You need to go.
Thank you very much to my senior my lords. I'll take about 15 minutes. Mercifully, my issues are issues of law, they will not incite any shooting up from respondents, or should not. My Lords, my Lords and your Ladyship, I have submitted some two cases. The first case is the case of Standard Chartered Financial Services and another versus Manchester Outfitters. I don't know that you have that with you. And the second is a case called Naveen Premjikerai versus Virunga Limited and others. In the case of Standard Chartered Financial Services Limited versus Manchester Outfitters, and this remains, as far as I'm aware, the first case where the Court of Appeal reviewed a judgment, a concluded judgment, set it aside and varied it. And the only question before that court that led it to this decision was the question of bias. I invite my Lords and your Ladyship to paragraph 1 of the decision, where the court says as follows, in trying to frame the seriousness of the issue. And I'm reading from the second line. It is a rare application in which the applicants seek to have the judgment of this court reopened, re-examined, declared nullity, set aside, and the appeal had afresh. I invite you now to go to paragraph 9. We've done back-to-back photocopying, but if you look at paragraph 9, in the middle is in bold the words Jasbir Singh Rai and two others versus Talokan Singh Rai. And the court is saying what it held. And it says this. During the pendency, my Lords and your Ladyship, are you there? In the middle of paragraph 9. During the pendency of the applicant's motion and the respondent's preliminary objection, this court, in a 5-judge bench decision in Jasbir, and they give the whole case there, held inter alia, that it was only mandated to hear and determine appeals from the High Court and could not revisit its own previously concluded decision, nor did it have powers to reopen and rehear a finally concluded matter. In light of the decision in the Rai case, it was deemed appropriate that since this matter raises similar issues, it be similarly heard by a 5-judge bench, hence the unusual composition of this bench. They are merely underlining the importance of the matter the court was dealing with. Permit me now, your Ladyship and my Lords, to invite you to paragraph 63, where the question that vexes you this afternoon is dealt with. At paragraph 63, they deal with a case which we've also supplied the court and my friends with. This is a well-known case of Senator Agostino Pinochet. But at paragraph 63, this is what they say. Bias, whether it is perceived or actual, undermines the public confidence in a judicial officer's ability to dispense justice. They then cite a caption by Lord Joff in R versus Gao. Justice must be rooted in confidence, and confidence is destroyed when right-minded people, the right-minded people that Mr. Ndegwa was talking about, go away thinking the judge was biased. At paragraph 65, the case of Webb versus Queen, in considering the merits of the test to be applied in a case where a juror is alleged to be biased, it is important to keep in mind that the appearance as well as the fact of impartiality has been done. And this is what they say at paragraph 66. And this, my Lords and your Ladyship, is what I would be beseeching this court to find favor with when you retire to do your ruling. The rule against bias is as important an element of the right to a fair trial. This rule, and now this is our own 5-judge bench saying this in the Court of Appeal, this rule is to be very strictly applied so that even the appearance of bias is done away with, the appearance alone. This is because it aids in public confidence in the fairness and impartiality of the judicial system. In view of the jurisprudential importance and uniqueness of this application, they then cite a case called R versus Sussex. Justice should not only be done, but should manifestly and undoubtedly